Uh, Hello everyone. So I am Manya Jain. Today in the video I will cover the brief overview of Limitation Act 1963, which is an important act for all the law students, judiciary aspirants and CS executive aspirants as well. So let's see what we'll cover in the today's video. That is the overview. So in the video, we'll see the introduction, then period of limitation and prescribed period, then disability, which is covered in the section 6 to 8, then bar of limitation, section 12, section 4, condonation of delay, which is very important section 5, then section 9 and then section 18. Now we'll see the introduction. So basically, when the word limitation comes to our mind, so what is the purpose of limitation? It is like superseding the company law, the companies act. It is superseding each and every act. So what is the purpose? So basically, the judiciary, the legislature, the executive, everyone wants that the person should be vigilant towards its rights. One should not sleep over his rights. So limitation basically sets a limit, a time limit for filing the suit and proceedings, like filing a suit, appeal, and application. There should be a time limit, otherwise the proceedings will never end. So basically the two main object of the limitation act are: the interest of the state requires that there should be an end to the litigation. If there won't be limitation act, then the suits, the cases would go on for years and years. Then second is the law assists the vigilant and not the one who sleeps over his rights. So this is the main two objectives of the limitation act. Next, we proceed with the so we all have heard the maxim "ubi jus ibi remedium," which means where there is a right, there is a remedy. But there is also a famous saying or famous line for Limitation Act that the rule of limitation thus will only bar the remedy but do not extinguish the right. But if we read the ubi just ibi remedium, which is applicable in all the laws, and it is a basic legal maxim. So it says where there is a right, there is a remedy. It is saying that there is a right, there is a remedy. But rule of limitation says it only bars the remedy but not the right. Aren't these contradicting? So let's understand through an example. What is this line saying? The rule of limitation bars only the remedy but not the right. So in the case of money recovery, the limitation period as per the act is 3 years. But what after 3 years? Can't you file like I have given money to someone B? Okay, so he owes me money and he didn't give me back. But it's been 3 years, so I can't file a suit of recovery after 3 years as per the act. But what about my money? Where is my right to recover the money? So as per the limitation, the remedy, which is like filing of the suit, will only be barred but not the right. How? Because as per, like, if you go back to Indian Contract Act, as per the section 25(3), which talks about agreement without consideration, the clause 3 says that agreement without consideration money can be recovered if the promise to pay a time bar debt. If a promise is made, like B makes me a promise that I will pay your debt, I make a promise. So in this case, what I am giving? Nothing, but what he is giving is the promise. So this is an agreement without the consideration. So here the right exists if the B makes a promise that he will give my money back. So here the right is there, my right is there to recover the money, but I cannot file the suit of recovery. So, but there is an exception which is mentioned in 27. Let's see what is adverse possession. Adverse possession is somebody is like some a tenant is staying at my house. Okay, so he is staying for 12 years, like kabza kar liya without renewing the rent deed or anything. So he is staying without any renewing the deed. He has adversely possessed that house. So in this case, right and remedy both ceases. After 12 years I can never get my house back. I cannot file a suit, I cannot file anything after 12 years once the house is adversely possessed by that person. So it is an exception case. In this case, both right and remedy ceases. Then let's proceed towards the important definitions. So there is one very important definition mentioned in Section 2J, that is the period of limitation. So in the schedule of the act, we'll see the three columns. One is description of suit, like money recovery, I told you, then limitation period 3 years, and commencement. It commences the day when I give the money and it has been defaulted. So from that day, the 3 years begin. So this column, the limitation period of 3 years, is the period of limitation. The Act prescribes a period of limitation in articles in schedule to the Act. Then second part of the definition says the prescribed period. The period of limitation computed in accordance with the provisions of Act. When we calculate a certain date, then that is known as prescribed period. So period of limitation is different from prescribed period. Now let's come to the disability. Uh, now, disability is covered majorly in section 678. 67 has to be read by with the section 8. Now let's see the section 6. So section 6, which says the legal disability. So the section 6 only implies in the cases of suits and the application for the execution of decree. If you go back to CPC, the order 21, which talks about execution of decree, so application under that order and the suits will only be covered by section 6. So in this case, at the time of prescribed period is that when the time is calculated, if that person is minor, insane, or idiot. So basically, the main difference between insane and idiot is insane may or may not be by birth, but idiot is always by birth. That insanity is by birth. So the period is to be calculated from the date the disability ceases. So now we have to calculate the time. Let's take an example. This. So father and mother were there. They had a son. They had a daughter. The son was 5 years and daughter was 2 years. Father and mother died in an accident. There has to be filed a suit. The suit was supposed to be filed where suppose the limitation period was of 12 years, then the son is 5 years, daughter is 2 years. So the son will attain the majority, he comes under the disability of minority. So after he will attain the majority in 13 years. 5 plus 13 is equals to 18. So 13 years he will attain the majority. Then after that 13, then he'll get 12 more years, because limitation period will begin after he attains the majority. So 13 plus 12 is equals to 25 years. So the prescribed period in this situation under section 6, only I am talking about 6, will be 25 years. And then the clause 2 of the section 6 talks about double legal disability. If that son was a minor plus insane, suppose he attained the majority in 13 years, then after that in on 17th birthday he was declared as insane also. So and he recovered from insanity after 10 years. So the prescribed period is will be 13 plus 10 plus 12 is equals to, that is 35 years. This was the question of legal disability. Now let's proceed towards the section 7, that is disability of one of several persons. So again, this section is simply applicable to suits and application for the execution of a decree. So these applies to a case whose substantive rights is joint. Now, for example, let's take the example of a partnership. There are three partners, A, B, C. Obviously, as per the section 4 of the Partnership Act, the A, B, C forms a firm. So suppose B gets insane. Okay, so after that B gets insane and there has to be suit filed. So it is not that till the time B will be fine then only the suit will be filed. A and C being the agent, partner is also the act as an agent under section 18 of the Partnership Act. So A and C also have an equal responsibility or equal right to file that suit. So therefore A and C can act behalf of B, and they are bound by as they are in partnership, they are bound by each other's actions. Each have an equal legal discharge. This was an example of partnership. So here we can see disability of one of several persons. So then another example can be of karta. Karta, we all know that he can alienate the property on behalf of the co-partner. He has the like power to do the alienation on the basis of three things: legal disability, indispensable duty, and benefit of estate. And in being his indispensable duty, he has to maintain each and every member of the family. So if a suit is filed, then karta has a right then karta has a responsibility to discharge his responsibility to discharge that person from a legal suit of recovery, or some suit is filed against that person. So karta has to discharge that person behalf of any member. So he has that disability of one of several persons. Then comes very important section, that is section 8. Now basically this nullifies what we have studied in section 6 or 7. So this basically is a proviso to section 6 and 7. It says it says when the disability, like for example minority ceases, from that date the time period which is there with the person to file the suit is maximum of 3 years. The heading of this section 8 says special exception. So nothing in section 6 or in 7 applies to suits to enforce rights of preemption or shall be deemed to extend for more than 3 years from the cessation of the disability or the death of the person affected thereby. The period of limitation for any suit or application. For example, let's understand through these two examples. So there was a father, mother, son, and the son and daughter was born out of their wedlock. Son was 2 years and daughter was 1 year. Again, father and mother died in an accident. So out of son and daughter, son will attain the majority first. So let's calculate of the son. So after 16 years, son will become major. Okay, so that's 16 years. And the suit, the limitation period as per the act and schedule was 12 years. So we'll see that 12 minus 16 is equals to minus 4. So as per this act, the disability and the period is disability is more than the period of limitation. So in this case, 12 minus 16 minus 4, which is equivalent to 0. So what we'll see, as per section 8, it is giving 3 years. So 0 is better or 3 is better? Obviously 3. So we'll see then that person will have only 3 years. In section C, what we saw, that the person will have 12 plus 16 years. It is not the case. As per section 8, he will have 3 years. Then after that, next example is father and mother, their son and daughter were born. Suppose son was of 12 years and daughter was of 10 years. Again, son will attain the majority first. So son is of 12 years plus 6 years. If we add in 6 years, he will become major. So that's 6 years. So if we subtract from 12 minus 6 is equals to 6. So 6 or 3. As per the act, 3 years. He will get only 3 years in this case. Then comes the then disability is over in 678. Now we'll see the section 3, which mentions the bar of limitation. So in this section talks about in cases of suit, appeal, or application. Application, for example, for a temporary injunction or arrest or attachment of property. Those applications which we saw in the CPC. Then suit, appeal, or application shall be dismissed. So in this case, the section casts a mandatory duty on the court to dismiss it if it is beyond the period of limitation. Suppose 3 साल हो गए, in case of money recovery of only 3 साल हो गए, then court can dismiss that case. Shall be dismissed, not can, it has to dismiss the case. What is there in the English law in UK? Generally, the defense must be pleaded by defendant. Defendant must say that it is this suit is barred by time limitation. Court will not see, but in India, court will see and they will dismiss the suit on the basis of limitation. So this is what section 3 says. The court has the mandatory duty to dismiss if it is time barred. Then in section 3, the section 3 is subject to section 4 to 24. If you read the section, it's the first line says subject to the provisions contained in section 4 to 24 inclusive every suit instituted, appeal, preferred, and application made after the prescribed period shall be dismissed. So if we'll divide the 4 to 24, we'll further see in the video only that section 4 to 11 talks about exceptions and section 12 to 24 talks about exclusions. So this is a mandatory provision, and we'll see what is the difference between exceptions and exclusions in the further presentation. So what does now section 4 talks about? Section 4 talks about basically in case of technical default. The heading of the section 4 is expiry of prescribed period when court is closed. So it is one of the exception which we talked about in section 3. It says, like, if court is closed, then what will happen? Like, I my the time period of my filing of the suit was on 26th Jan. It was expiring on 26th Jan. But 26th Jan, we all know that it is a national holiday. So what will happen? As per this section, my the date which is ending will be extended to 27th Jan. I will have one more day to file the suit, because basically this in this court is saying, because if it is not possible, they can't compel him to do something which is not possible. He can't compel me. If court is closed, it is not in my hands, it is neither in the court's hands. So the day will be extended to 27 Jan, because it was a national holiday. And maybe not a national holiday, if for some reason court is closed, then what is the mistake of the person who is filing the suit? So this is where this section 4 will come into play. So it is an exceptional case. Then let's see one case of exclusion of time, that is section 12. Section 12 says, when the course of action has been done, like the course of action, the money recovery suit starts from when the default happens. So from the date of default, that date of default shall be excluded. So in this section, any suit, appeal or application, the day from which such period is to be reckoned shall be excluded. So a suit of, so let's see the example. A suit for recovery of the suit for recovery of loan has to be filed within 3 years of the date of granting the loan. So he has a note receipt was dated 5/9/1991, that is 5th September, and the suit filed on 5th September 1994 would be within time period, because the date, like 5th September 1991, I can file this suit on 5th September 1994. I am not by time barred, because that date of 5th September 1991 shall be excluded. So basically, I have fifth that my time period will expire on 6th September 1994. So this is what section 12 is saying. It's basically excluding the day of course of action. For example, in this section, if a case suit was there, it was judged, and the decree was yet to come. So before filing an appeal, generally 90 days are taken to give the decree. We have time of 90 days, and suppose the judgment copy, which has to be given immediately or after a few days, it took more than 90 daes, and my time period to file an appeal is gone. So that if the error is on the because of the court, that copy was delayed on because of the court, then I will have 90 days more to file the appeal. That days which were wasted by the court in giving the copy will be excluded. So the section 4 talked about the exception, which we talked in section 3, and section 12 talks about exclusion of time, which we talked in section 3. Then comes the very important section, which generally is told that it comes in the exam of 25 marks. So which says condonation of delay. Basically, section 5's heading is extension of prescribed period in certain cases. So what is best? First of all, condonation of delay. Basically, maafi. Condonation is maafi, forgiveness of delay. So extension of prescribed period in certain cases. The word to be two keywords of this section is may, which gives a discretion of the court, which we can make out that it is a discretion of the court. And second is sufficient cause. Now let's read the section in detail. Basically, this section applies to only in two things: appeal and application. It basically excludes the applications made under the provision of Order 21, which is the execution of decree. Previously, we saw that applications for under Order 21 were on which section 6 and 7 was applicable, but in section 5, appeal and application, or it is only applicable on appeal and application, and the application made under Order 21 are excluded. So basically, this section gives a double discretion. Let's see how. First discretion, first discretion, which is very everyday evidential, that is the may. May in the section gives a discretion of the court. But there are still more double discretion. How? It says like if the sufficient cause is shown by the party, then court may grant, may extend the time, and may adjourn that case, may take up that case. So, but after proving the sufficient cause, it is in the hands of the court to allow or disallow that party to file an appeal or file an application. Let's understand through the example. Suppose there was a husband and a wife, and a divorce decree was passed. So to against that decree, wife had 90 days to appeal. After that, she reached 110th day to the court after like 20 days. And she said that I met a very severe accident and I was hospitalized for so many days. Now I realize I have to file an appeal. But after 90 days, husband says that there was no appeal filed. So on the 91st day, he marries to W2. Then now court has seen that there is a sufficient cause. There is an accident, there's genuinely an accident of W, that is why she is not able to file appeal. But will, like, sufficient cause is proven, but it is still the court's discretion whether to allow or disallow. If court allows, will it not be the injustice to W2? Because W2 and H both, husband both, because like they are married. And what about if the appeal is allowed and divorce is not? What about W2? Is it not unjusticiable to there? So again, we can see that how double discretion is there in section 5. Court allow or can disallow after the proving of the sufficient cause also. So this was all in the section 5. But an important case which gives a guidelines when to use section 5. Section 5, which says guidelines for section in the case. Ordinarily, a litigant does not stand to benefit from an appeal. There is no presumption that delay is to be necessarily caused by malafide of litigant. So there is no presumption कि हाँ भाई अगर वो delay कर रहा है, one party is going for delay, तो उसका भाई उसका जो वो है intention, उसका intention वही है कि वो रिफ्यूजिंग मतलब कि वो उसका मालाफाइड इंटेंशन और जान के डिले कर रहा है. दिस इज नॉट द केस. Then say third is refusing to condone delay can cause now let's understand two situation. If court, like there are two options with the court, either to refuse to listen to the case on the basis of technical default, that is a time barred or something related to limitation, that is all the technical things, or maybe dismiss the case after listening on the basis of merit. So what is better? Obviously, if we see with the principle of natural justice and justice, the court should dismiss the suit on the basis of merits. So refusing to condone delay can cause a meritorious matter to be thrown out at a very threshold and cause justice to be defeated. अब बिना सुने किसी पार्टी को आप dismiss कर रहे हो तो it is like a big threat to the justice, right? So this is what the third condition says. Then every day's delay must be explained does not mean the doctrine is to be applied in an irrational manner. Suppose like if the case in the name of wife only, she came on the 110th day. So after 20 days. So the court should not ask in the case like what did you do, what did you eat of each and every day. Court cannot have that diary and nobody can remember. Even I don't remember what did I had in my lunch. So similarly, every day's delay must be explained does not mean it has to be applied in an like irrational andhadhun way. Then fifth is between substantial justice and technical considerations. The former deserves to be preferred, for the other side cannot claim that injustice is done because of a bona fide delay. But it has to be applied with like very rational way, like balance of convenience, and everything has to be looked after. If we are condoning someone, it does not mean that it should be injusticiable to the other party. So the former deserves to be preferred, for the other side cannot claim that injustice is done. And the other party, if the delay is condoned to one party, the other party cannot say that it is injustice. No, it is not that way. So these were the five guidelines which came in the very famous case of collector land acquisition Anantnag versus Katiji. It is a landmark case on this case, in this on this section. Then small two sections are left. It is a section 9 continuous running of time. So section 9 says once the time has started it will not stop after the cessation of the disability. Suppose I get major today, and tomorrow I get insane, but my time will start running because I have turned major today. It doesn't mean that tomorrow I have got insane the time will stop. The time will keep on running. This is what this section says. Where once time has begun to run, no subsequent disability. Subsequent disabilities like my insanity or inability to institute a suit or make an application stops it. It will that 3 years or the whatever the limitation period is, it will keep on running. But there is a proviso which needs to be understood in like little detail. Provided that where letters of administration to the estate of a creditor have been granted to his debtor, the running of the period of limitation for a suit to recover the debt shall be suspended while the administration continues. So there is a proviso to this section 9. There is one like exceptional case which says, for example, let's understand with the example. There was a father. Okay, he had two sons, son 1 and son 2. He took the loan from Z, and he also gave the loan to A. Father dies and the court administers X. He sent the letter by through the letter of administration that you will administer his property. The letter of administration basically to handle and to manage the properties of the deceased. So X was given the letter of authorized administration. So in this case, like somebody else is administered. So if the suit is filed to take the money from A, the time will be stopped. There will be the suspension of time. Like if we read the proviso again, it says have been granted to his debtor the running of the period of limitation for a suit to recover the debt. Like the suit which has to be filed against A shall be suspended while the administration continues. जब तक एक्स सारी प्रॉपर्टीज हैंडल कर रहा है तब तक वो टाइम सस्पेंड रहेगा. ये नहीं कि वो 3 साल चलते रहेंगे नहीं. वो टाइम सस्पेंड हो जाएगा. कोई टाइम लिमिट नहीं है जब तक एक्स वो हैंडल कर रहा है. If suppose, now let's understand a different situation in this case. If S1 was given the letter of administration by the court, so in the case of S1, as per the like law, as per the Hindu law or any Muslim law, the when will the property of the father will be inherited by S1 and S2 after the paying of the funeral expenses, then after paying off the debt, then net has to be distributed to heir. So if S1 is administered, first he has to pay the funeral expenses, then he has to repay the debt of Z, and then he has the right to distribute that property. So till the time X or S1 has the letter of author administration, the running of the period of limitation time will be suspended. So this is what section 9 proviso said. Now let's see the section 18, which is the last section of in the today's video, which is an important from the perspective of judiciary, which says that it deals with the effect of acknowledgement in writing. So the it mentions the word very important that the acknowledgement must be in writing. For example, there is one loan like if we see the in the cases of house loan, like I took a house loan of 25 years, but the time to recovery is 3 years. How is it balanced? So like after every time I pay the installment, it gets renewed. Then I paid another installment, the 3 years get renewed. So this will go on, this cycle will go on. Each time I pay the installment, once I default, then the 3 years will start. Like if till the 3 years on my default of the installment, bank has not taken the action, then that time will suspend. Then the bank will lose its right to file the suit of recovery against me. So it must be an acknowledgement of debt. So I'm writing, I'm taking I'm signing a loan deed or something, that I have taken the loan or I am paying the installment I'm showing in the ledger. So there is some written form. So it must be an acknowledgement of debt as such and must involve an admission of a subsisting relationship of debtor and creditor and an intention to continue it until it is lawfully determined must also be evident. Similarly, something else, like if I haven't signed anything but it shows in my ledger, in my accounts, that I am paying the installment, so it is an acknowledgement that I have taken the loan from the bank. So this is what the section 18 says. It must that acknowledgement must exist in writing. So here the video ends. Thank you. I hope that all sections were, like the sections which I covered were clear. So thank you so much.